Kev, teach us.
Okay, just one more idea, a quick idea from Parshat Teruma. And it says here, it says here, um, it stresses the importance of giving. Now, giving tzedakah, charity, and people gave whatever they could for the Mishkan in terms of materials, jewelry, and I'm not sure if they gave money, but if one can get into that habit of giving tzedakah, just being giving, it doesn't matter what the amount is, and it's and develop that habit, so to speak. It's a very positive thing, and it's just brings positive, and you can help others. Just it's a positive act, uh, giving tzedakah, giving of your time, etc. So because everyone gave whatever they could to the Mishkan. And it's also just being unselfish and giving of yourself, giving of your resources, etc.
Sure. It's a good point. It's a very, very good point. Sometimes also giving of your time and expertise. If each
Mm.
of you got an expertise, that makes sense. I remember when my brother was a mechanic apprentice and then a mechanic before he had his own business, he used to offer his services to the Chevra Kadisha to conduct funerals because he didn't have any money. And he did that for a few years. Which was quite something. All right, let's get started. Um, I just want to do the share in a refuah of um, um, Aryeh ben Esther, and we discussed capital cases. Now, Rava goes on to extend this distinction of to basically monetary cases, a case of fines using an example of fines levied against the thieves. So if you remember in Exodus, Shmot chapter 22, verse 6, it basically discusses a thief who is caught must not only return what he has stolen, or if it's no longer intact, he pays the financial equivalent for it, but he must also pay a fine equal to the value of that which he stole. In other words, he pays a total of double what he stole, which is a kefil. It's known as a kefil payment. If he stole cattle or sheep and subsequently slaughtered them or sold them, we went through this a lot in Bava Kama, he pays a total of fourfold for the sheep and fivefold for the cattle. Okay? And that's what we're talking about here. So we're saying, look, according to Rava, the same principle applies to payments of fines. If two witnesses came and said, on Sunday that person stole a sheep or ox and then slaughtered or sold it, and two others came and said, hang on Sunday you were with us at another location and could not have seen this. However, on Monday, the defendant stole and then slaughtered or sold it, they pay the intended victim. Okay. Moreover, even if they said on that previous Friday he stole and then slaughtered or sold it, they pay the intended victim. Why? Because at the time they testified, the man was not subject to paying the fine since the obligation had not yet been established in court. So what does this mean? Is if he were to confess his crime, he would be obligated to pay only the principal but not the additional fine. There's a principle that one who confesses to a crime that is subject to a fine is exempt from paying the fine. Where did we learn this? It was in Bava Kama 64b, you guys remember? Because the liability to a fine exists only if it's been established in court by the testimony of witnesses. Meaning, if you don't waste the court's time and return what you stole or pay that equivalent, then the court doesn't issue a fine for wasting the time of the witnesses nor the court, and therefore, by self-confession, you only have to pay the principal. So what happened is he was not subject to paying the fine because he hasn't yet been established in the process of legal proceedings to owe that fine. Guys, give me 1 second. There's a lot of traffic noise. I'm just closing the door. 1 moment, please. Okay. So the Gemara, guys, now gives the parallel rule for witnesses testifying about a fine that has already been assessed. You can see the same issue has been played out in a capital case. So the Gemara says, however, if two witnesses came and said, on Sunday he stole and then slaughtered or sold it and was sentenced to pay the fine, and two others came and said, on Sunday you were with us at another location and couldn't have seen his sentencing. However, on the previous Friday he stole and then slaughtered or sold it and was sentenced. And moreover, even if they said on Sunday he stole and then slaughtered or sold it, and on the Monday was sentenced, the Zomimim witnesses do not pay. For at that time they testified, say for example, they're testifying this Thursday, the 27th, about an event that happened on Monday, the 23rd, or alternatively on Friday, the 21st, as long as the man was sentenced and therefore by the court subject to paying the fine, the Zomimim sought to impose upon him, then the reciprocal penalty doesn't get pushed forward to them. Why? Because there's a central point of Rava's teaching. And if we just cover this for the next 5 or 10 minutes, I'm happy, and then we can finish the show. Remember, we don't always have to do 40 minutes. Whatever we do is better than nothing. So basically, I want you guys to remember that a central point of Rava's ruling is that witnesses who testify falsely about something are subject to the reciprocal hazama penalty, even if it turns out that what they said actually happened. Why? Since they did not see it happen, their testimony was false, and they deserve to be punished for their false testimony. The guilt of the accused is not in itself sufficient to exempt them. Just remember. And just remember, Lance and Gavin made this error initially, but I'm sure they've wisened up. It's not about wasting the court's time. It's about corrupting the justice system and having an innocent person convicted. So you might say, well, in this case, the person wasn't innocent, which is exactly why the Gemara has this whole case with Rava. The point of it is, what is considered innocence means the court has not found him guilty with a verdict at that point, and therefore legally he's innocent, because what's considered a din base, a base din or Sanhedrin conviction is the point at which they are guilty to pay anyway for that offense, whether it's corporal, capital, or monetary. And therefore, what they intended to do to the victim has already been convicted of. And therefore, they're not looking to do anything to the victim that has not already been implemented through the conviction process. But up until that point, even if the crime was being committed, they deserve to get the reciprocal penalty, because the victim was not convicted, even though he might have caused the crime, and they did not see it. So the distinction made here by Rav is as follows. A person's guilty of a crime which incurs a fine, and he can, by the way, in this financial issue, exempt himself from that fine by confessing his guilt. Okay? If you want to know, just remember Bavli 64b. You guys remember, I'm saying it for Lance and Brendan. Therefore, the witnesses who testified falsely that they saw him commit this crime basically attempted to subject him to an obligation which he might never have had to pay despite his guilt, because all he would have to pay is that which he stole, or return that which he stole. So therefore, they're liable to the reciprocal penalty according to Rashi. And this is not the case when he's already been convicted. Why? Because at that point, he can no longer exempt himself by confessing, even in a different court. because they uphold the testimony. And therefore, the false testimony of the Eidim Zomimim are only imposing on him a loss he was destined to suffer anyway. So they're therefore exempt from the Hazamah penalty. The same would be true if they testified about a monetary obligation. Let me give you two examples of a monetary obligation. You've got a debt that you owe, or you've got damages that you caused, as opposed to a fine. So it's failure to pay a creditor back on money owing, or it's damage caused to somebody else's property. And since there were witnesses to the obligation, it's clear that he'd eventually have to pay that obligation. And basically, their false testimony did not impose any liability on him at which he would not have paid in any case. So the Zomimim witnesses are therefore exempt from the Hazamah penalty. What are we saying here is that there are two particular viewpoints. The one viewpoint of the Torah in regard to monetary cases is different to a fine. A fine is a court-imposed penalty. It's punitive in nature. Whereas, let me ask you guys something. Lance, if I back up my car and hit your car and drive off, do I have to pay?
If you,
If I smash your car and damage your car, do I
yeah,
have to pay? So the Torah's view of it is there's a spiritual and Torah obligation apart from the legal obligation, which means there's not a question there. It's different to a fine. A fine is the lack of cooperation. In terms of returning what you stole, that's a biblical commandment. That's a biblical commandment. If you damage, you must pay. So therefore, in terms of monetary obligations, the Eidim Zomimim, if it was found that the case was to be true, some of the opinions of the Gemara is that they're not made to pay the reciprocal penalty as such, because it's different to a capital case, because a capital case specifically is a case where the Sanhedrin are trying everything they can to get this person off the hook. As regards to monetary obligations, the Sanhedrin tries to make sure that the guilty person that damaged or didn't pay back a debt pays it back. And therefore, they're more stringent because they're saying the Eidim Zomimim are not really trying to do anything that wasn't caused by this person's actions. So there's less of an issue with regards to conviction compared to a capital case or a punitive sort of measure. But in any case, unless that person is convicted, the Eidim Zomimim generally, according to most opinions, have to pay the reciprocal penalty because what they said was not truthful. And even if the person technically owed the money for a debt or damage, unless it's proven, the Eidim Zomimim have to pay. If it's proven, in fact, that the money is owed anyway, then obviously the parties, when the Eidim Zomimim said this person owes a debt, they would come to the fore. Because one thing that you've got to be aware of is that the onus on the person that's extracting the money has to prove the case. So in other words, if you take witnesses aside, if I say you damaged my property, I would need to prove it. If I say you owed me money, I would need to prove it. The person extracting the money has to prove his case. That's one of the principles that we learn. So a similar rationale applies in capital cases, okay? In other words, in such cases, the courts are obligated to subject the witnesses to a far more rigorous and detailed examination than in monetary matters in an attempt to save the accused from execution. This is brought forward by Rashi and other opinions, since even truthful witnesses will sometimes be disqualified by contradicting each other. Remember, contradicting testimony is not conspiring testimony. They actually were there. They might just got the facts mixed up on some minor point, for example. There's always a degree of uncertainty whether even a guilty person will actually be executed. So on that basis, the false witnesses were attempting to bring about the execution of a person who at the time was certain ever to be executed. Who knew if it was warned, if he would have followed a warning, if he would have acknowledged the consequence of that warning. So therefore, they're certainly subject to a reciprocal hazama penalty for that attempt, even though the person accused is eventually found guilty and executed. So, guys, it's not the same in a monetary case where if there are true witnesses to the obligation, it's considered virtually certain that the court will obligate him to pay. So according to certain opinions, unlike a fine, where he really has to be uncooperative to get it, if he's damaged or he's hasn't paid back a debt, it's going to come to the fore because that person wants their money. So the same argument could actually be made even when they testify against a person who has been sentenced to death in another court, for example, but escaped. Okay? Since the second court often will not easily accept testimony about his earlier conviction, there's some doubt, even if that conviction took place, whether he will eventually be executed. However, in that case, the reason why the Eidim Zomimim are exempt from being executed is for a completely different reason. It's not that this person, because I was thinking about what Lon said, it's possible a person could live longer, etc. But we talk about a case where he's been sentenced. In one court, he escapes, and then Eidim Zomimim figure they don't want this lunatic running around because they're scared of him. So they basically gave false testimony. The reason why, even if it's found out later that there was another conviction and eventually it's overturned by a second court on a technicality, the reason why the Eidim Zomimim don't get killed is, yes, that person was under a death sentence at the time they testified against him. And actually, they're only guilty of having tried to kill a person who's considered legally dead, for which they couldn't have been convicted even if they killed him with their own hands, according to Sanhedrin. So therefore, they can't be convicted as Zomimim either. And that's according to the Tosfot and Ritva. So there are other Rabbonim that explain Rava's distinction differently. In other words, there's an essential difference between monetary obligations and fines. When there is a financial liability, in other words, a payment of a loan or damages, the court merely clarifies the facts and applies the law. But the obligation, halachically and from a Torah ethics point of view, exists independently of the court's ruling from the time of the loan or damage. Meaning, in Shamayim, this person didn't pay back a loan, or they damaged somebody's property and they didn't pay to fix it up. So that is a halachic obligation. The courts are only there to implement that and clarify that the person needs to pay. Just give me 1 second. So, slightly different because in the case of fines, however, there's no inherent liability. Why? Because the obligation is actually imposed by the court and takes effect only from the time of the ruling. So the person who knows himself to be guilty of a crime for which he should be fined, he actually has no obligation to pay that fine. Yes, he should pay back the principal, but that fine he doesn't have to pay unless he's caught up by a group of witnesses. Then the court fines him. So he doesn't have the same spiritual obligation to pay the fine as he does to pay what he actually cost in terms of damages or lack of payment for that which he stole. So consequently, if witnesses who had not seen the crime testify against him, they have actually plotted to make him pay a fine, which he was not liable at the time to pay, even if he was actually guilty of the crime at which they accuse him, because all he has to pay back is the principal. And it's not the case with a monetary obligation, where the accused is in any case liable, even without their testimony, by virtue of the Torah. The Sanhedrin implements the law, but it's the Torah that tells him. So thus, even though their testimony was false, it didn't impose on the defendant anything which he did not truly owe. So that's according to some opinions. In other words, the witnesses, and according to some opinions, say they therefore exempt from paying the hazamah penalty when it regards a actual loan or damages, if it's found that the person is guilty, even if he isn't convicted. Why? Because the Torah says he has to pay that back. So he doesn't need a conviction there, whereas a fine, there has to be a conviction, the same as corporal and capital punishment. However, once the court imposes the fine, it becomes an obligation like any other monetary obligation. So therefore, if the witnesses testify falsely that they saw him sentenced to pay a fine, and it turns out that it indeed been fined, the false witnesses are exempt in that case from paying the hazama penalty because this person was convicted in court of paying the principal and the fine, and therefore they didn't impose any penalty on him of the fine that he wasn't truly obligated to pay because he messed around the court. So capital cases are the same in this respect. There's no inherent death sentence on the criminal unless he's convicted in court. Therefore, if witnesses, guys, testify falsely that they saw him kill somebody, they're executed for their testimony, even if it turns out the accused was really guilty. Why? He was not subject to execution at that time they testified because he wasn't convicted yet. He committed the crime. They attempted to bring about the death of a person who was not liable for execution at the time. However, if they testify falsely that they saw him sentenced to death in another court or that he was guilty, and it turns out that he had been sentenced, or they said he was guilty of murder, but he had been sentenced. Either way, they're not executed for their false testimony because they plotted to bring about the death of someone who really was liable to execution. This is added commentary by Rabbi Kiva Eiger. All right, guys, I think we're done for the day.
Yeah.
Any questions? You've got 3 minutes. Yep.
Just a quick one. So with monetary penalties, okay, so if you steal a cow or a sheep, you're paying back 4 times or 5 times, okay? Now just say there's 80 Zomimim, and then they're proven to be false witnesses. Are they liable also for like 4 times or 5 times?
That's an excellent question. So Lance is asking a bit more of a technical question. I'm going to make your question even stronger. If, according to some opinions, there was a monetary obligation to return the principal amount, just remember 5 times for the ox is actually once of the principal and 4 times that. And 4 times for the sheep is 1 principal amount and 3 times that. So the question is, according to certain opinions, since somebody has a Torah obligation to any of that, would they pay the 3 times for the sheep and 4 times for the cow because they don't owe for the principal because that person had a monetary obligation to pay it according to Torah anyway? Okay, just hear me, Lance. Or is it the fact that because they were Adim Zomimim, since they sought to cost this person the entire amount, they're still made to pay 4 times for a sheep or 5 times for an ox? They're made to pay 4 times for a sheep and 5 times for an ox. And the same thing, he shall pay double because what they sought to do to this person is done to him. Now, had they played the game and they just accused him of, say, for example, it's easier in a case where it's damages. Say, for example, that. Or they're not trying to make him pay double. And that's just said he damaged somebody for 6 grand. And basically, he did. But it still has to go through the court process. But there might not have been a conviction. In certain opinions, since he owes the money halachically anyway, it's just a matter of time. The Adim Zomimim don't have to pay back the principal. In certain other cases, it works on conviction with monetary obligation by the court, irrespective of his Torah responsibility laws. You get it? Yeah. All right.
So,
Clark, I know everybody has to.
Damon, you can do a few extra downloads. She just cancelled my student, so we can. If you want to carry on for a few more minutes, I don't know about you guys. Sorry about that. She just sent me a message now.
You know what? The thing of it is, we're going to go
To Mincha Maariv.
another sort of topic on an analysis of Reish Lakish with Rav Yehuda, which is very complicated. So I think we'll leave it. I planned exactly for
But
6.
just one question.
You asked me to plan till 6. I planned to the minute. Yeah.
Thank you. Thanks. Yeah, I appreciate it. She just sent me a message. Pity she didn't send it to me yesterday. Then I could have. Anyway, anyway. She's getting charged for it anyway, so it's fine.
Okay, good for you. You remind me of my doctor.
Yeah.
Yeah. What were you going to ask?
So so I was just a bit tired, and I rushed back before the share, and because I was doing stuff earlier.
Yeah.
So the ADM Zomimim, in terms of monetary obligations. The liability of a woman who makes a false accusation against a defendant in a case. Are they liable for double penalty, or the actual full the full liability that the defendant would have been liable for? What are they
Okay.
liable for?
Okay, so they're two slightly different opinions, but the default position generally is what you sought to do to your victim is done to you as Adam Zimmerman. So if they said he stole a sheep and sorted or sold it, it then becomes a fivefold obligation, fourfold for the sheep, fivefold for an ox. And if they accuse him of stealing another item, he shall pay double. The Adam Zimmerman shall pay double. According to one or two opinions, the view is that since there's a Torah obligation anyway to return what you stole or pay for damages, they didn't seek to cost this defendant anything that he wouldn't have been liable to pay should he have been guilty with the crime with another set of witnesses. It was just a matter of time, even though he hasn't been convicted, because he has an obligation to pay it back, irrespective of the conviction process. But I think for the sake of simplicity, many would hold that the court would still have to follow due process and convict him with witnesses. The fact that he's responsible in Shemaim, Hashem will hold him responsible. So I think the default position is the Eidim Zomimim only get off if this person is convicted of the crime, because that which they sought to cost him, he's already obligated for. You get it? Yeah.
A quick question. Say somebody steals a sheep and he feels so bad he can't sleep, and the next day he takes the sheep back. So he paid back what he stole, but does he also have an obligation to like make up monetary wise?
No. So the four or fivefold payment is only a fine if witnesses come against him in court and he's convicted. So he only has to return the sheep or the sheep's value, because he was counting sheep that night because he couldn't sleep out of guilt. How's that? Okay. All right. I can't hear
Can't hear you, Gab. You're on mute.
I can see your hands, but
Thank you. Thank God I tell you. Thank God I tell you. No, so he counted one extra sheep that night.
He did.
He normally counts like 30, and now he counted one extra. People who count in the sheep who they steal, they're going to count an extra on whatever they stole. Guys, thank you. Thanks, David.
All right, guys, have a good evening. Sorry, I don't want to start anything else because I work my time out exactly.
Thank you. Thanks.
Yeah.
Okay.
No, you were spot on.
Cheers, guys. Have a great day.